Welcome to Landmark Chambers webinar, Subsidy Control, the New Regime. We're delighted to see so many of you joining the session today, and we hope you find the presentations and discussions to be useful and informative. My name is James Neill, and I will be chairing the session today. Sadly, Tim Bewley, KC, due to a family bereavement, can't make it today and sends his apologies. I'm going to be joined by Barney, McCay, who I'll introduce in a moment. Just by way of introduction, my name's James Neill. I'm the chair of the Public Procurement and State Aid Group at Landmark Chambers. I'm going to be speaking on the main changes to the UK subsidy control regime under the new Act. We're having a brief look at the subsidy control principles contained within the new Act. I'm joined today by Barney McCay. Barney is a junior tenant at Landmark Chambers. Before coming to the bar, Barney worked in competition and consumer policy, including on the UK's regime after state aid. The UK's state aid regime after Brexit. He now practices in public procurement law and state aid at Landmark. He's currently instructed in some high-profile litigation in the TCC, including the current National Lottery procurement litigation brought by Camelot. Just turning to my presentation. Main changes in the UK subsidy control under the Act and subsidy control principles. The way I'm going to tackle this, and the way I've sort of set this out for the purposes of today, this is going to be very much a canter through the main architecture and framework of the Act. We don't have time to go through each and every detail of all the provisions, but I'm just going to give you a sense of the main aspects of it and how that differs from the EU state aid regime, which some of you I'm sure will be familiar with. So as I set out on the screen, I'll start by looking at the current position, although to a certain extent that is fairly academic now, given that we only have a few weeks before the main Act comes in. I will then look at turn to the Subsidy Control Act and have a look at the definition of subsidy under the Act, look at the principles, look at the exemptions and what is permitted and prohibited subsidy, and then finally we'll look at the minimum financial assistance provisions and the streamlined route scheme that the Act sets out. So subsidy control, what is the current position? Well, just as a brief reminder of where we are now, under the State Aid Revocations and Amendment EU Regulations 2020, EU state aid law was abolished, so had no ongoing effect in UK law from the time of the EU exit, i.e. from the end of December 2020. The Trade and Cooperation Agreement provided a framework for saying what subsidy control law implemented by the UK must achieve, but it didn't actually specify any particular regime, and that differs to some other aspects of the TCA. So Article 366 just stated, each party shall have in place and maintain an effective system of subsidy control that ensures the granting of a subsidy respects the following principles, and then it then set out a series of principles that regime should adhere to. The EU Future Relationship Act 2020 didn't implement specific parts of the TCA applying to subsidy control into domestic law. As I say, unlike some other provisions, like, for example, the security regime. The UK, therefore, was, and in fact still is until the Act comes into force next month, was still effectively in a limbo period with no domestic regime governing subsidy control. So what did the government do? Well, BIS guidance issued on the 24th of June 2021 sought to fill in the gap by advising UK public authorities to comply with the UK's international commitments, including the TCA. And I've just put up on the screen what that guidance said. In essence, it said all public authorities should read this guidance and assure themselves they understand the UK's commitments and comply with their obligations in relation to the award of subsidies from the 1st of January 2021. And then it said, however, public authorities should also refer to the detail of the commitments set out in the WTO Agreement on Subsidies and the UK TCA and the Northern Ireland Protocol. So that was that's as much as there was any guidance or any provisions governing what should happen. It was really the BIS guidance that was the key document and still is as at this stage. So just in terms of a little bit more detail on the guidance. The guidance was not statutory guidance, so there was no express legal duty, and there still is no express legal duty to comply with it. It is probably enforceable in inverted commas as soft law under general public law principles relating to material considerations, but I don't think that's ever been tested, or at least there's been no definitive judgment on that. The guidance did have a section on enforcement and said that the government, it anticipated that the government would legislate, as it now has done in the Subsidy Control Bill, to give clarity on the role of the courts in subsidy cases. But it said public authorities should be mindful of the possibility that some complainants will challenge subsidy awards by reference to the principles and their effect in domestic law by virtue of the Act. So that was all that the guidance said, that there may be some challenge by reference to those principles and their effect, but not particularly clear one way or the other. So when looking at the actual provisions of the TCA, there is a definition of a subsidy, and that is the test of what might have an effect on UK-EU trade. There is a de minimis threshold, approximately 325,000 special drawing rights, approximately 336,000. And then Article 366 set out the main principles. There were 6 principles in the TCA, including the principles of necessity and proportionality, and the need to the authority satisfying itself it can't achieve an objective via less distortive means, and then the need to ensure positive contribution to the objective outweighs negatives from market distortion. So turning to the new Act, so that was the position up until, and it is the position up until the 4th of January 2023. But now we have the new Act, and that received royal assent on the 28th of April 2022. The substantive provisions will come into force on the 4th of January 2023. So any subsidy given on or after that date will be subject to the duties and procedures set out in the SCA 2020-22. Now, how does the architecture of the Act, how's that set out? It's actually a fairly clear piece of legislation in terms of its framework, and it's part 1 contains the definitions. Part 2 is the key part that contains what's referred to as the subsidy control requirements that apply to the giving of subsidies or the making of subsidy schemes. So that's the real meat of the the substantive provisions in that part. Part 3 sets out the exemptions to those subsidy control requirements. Then Part 4 sets out the CMA functions and enforcement, and that's what it's that section that Barney will be addressing in a bit more detail. So I'm not going to touch on that for my presentation. So what is a subsidy? So there are 4 tests for a subsidy under the Act. The key initial point is that it concerns financial assistance, and then there are four effectively tests for under financial assistance. So to meet the definition of subsidy. So firstly, financial assistance which is given directly or indirectly from public resources. Is given directly or indirectly from public resources by a public authority. It confers an economic advantage on one or more enterprises. It's specific, so it's the specificity test, that is such that it benefits one or more enterprises over one or more other enterprises with respect to the production of goods or the provision of services. And then it's capable or is capable of having an effect on competition or investment within the UK, trade between the UK and a country outside the UK, or investment as between the UK and a country or territory outside the United Kingdom. And I've just sort of underlined the key limb of paragraph D, i.e. competition or investment within the United Kingdom, because that's the big change from the EU state aid regime, and indeed the regime, so far as there was one under the TCA in the limbo period, that now subsidies are caught where they may have an intra effect on trade or investment in the UK. So now one has to consider when one's granting in a particular region or, for example, county of the UK, how that might affect trade across the UK and with in other parts of it. And that wasn't a requirement under any of the previous under either the EU regime or the TCA regime. Now, for those of you that are familiar with the state aid regime, broadly, those tests for what is a subsidy follows I say in broad terms, follows in broad terms the EU the test under Article 107(1) of the EU treaty. So if for those of you that can remember, Article 107(1) refers to whether something's state aid. It refers to there's 4 requirements. It has to be aid in the sense of an economic advantage through state resources. There was a test of selectivity, i.e. favouring certain undertakings. And then the 4th test, which broadly mirrors, subject to the qualification I've already raised, broadly mirrors limb D of the UK test. Now, for something to be a state aid, it had to be liable to distort competition and affect trade between member states. So the one area where arguably the test for a subsidy under UK law will now be narrower is the fact that in the SCA, it refers to financial assistance under Article 107 of the EU treaty. It was that the test is aid in any form whatsoever. So arguably the fact that subsidy is now limited to financial assistance is arguably slightly narrower than the very broad aid in whatever form whatsoever that we could find in Article 107. Now, financial assistance there's an inclusive definition in the Act, and so it's not so that there's no sort of finite or defined list of what could be included under financial assistance. But we're told under the Act that it can include a direct transfer of funds, guarantees, contingent transfer of funds, such as guarantees, foregoing of revenue that's otherwise due, provision of goods and services, and the purchase of goods and services. You'll also note that there's a reference to enterprises, so giving or conferring an economic advantage on an enterprise. An enterprise is defined under the Act in Section 7. I haven't given you the provision, but broadly, an enterprise means a person who's engaged in economic activity that entails offering goods or services on a market to the extent that the person is engaged in such an activity, or a group of persons under common ownership or control, which is likewise engaged in economic activity. Now, that broadly sort of follows or echoes the EU state aid regime and its reference to undertakings, and there's the same reference to economic. You'll be familiar with the reference there in the treaty to an undertaking being linked to an economic activity. So nothing particularly drastic in terms of any changes there in terms of the overall definition of approach to subsidy, bar the key point about it now it could have an effect on competition or investment within the UK and would therefore be cause. Now, moving to the sort of meat of the Act and the key substantive principles. So the key duty under the Act which applies to a public authority is Section 12 of the Act. I haven't put it up on the screen because I thought I'd just read that to you. It just says that a public authority must consider the subsidy control principles before deciding to give a subsidy, and must not give the subsidy unless it is of the view that the subsidy is consistent with those principles. So that's the key statutory duty that now applies when considering whether to grant a subsidy or not. The subsidy control principles are set out in the schedule at the back of the Act, and I've just summarized them here. There are 7 of them, I've sort of listed them here so that it's sort of for ease of reference. The first principle is that what's described as the common interest principle. Subsidies should pursue a specific policy objective in order to remedy an identified market failure, or B, address an equity rationale, such as local or regional disadvantage, social difficulty, or distributional concerns. Subsidy has to be proportionate and necessary. So they need to be proportionate to their specific policy objective and limited to what is necessary to achieve it. Subsidies have to be designed to change economic behavior of the beneficiary, and that change in relation to a subsidy should be conducive to achieving its specific policy objective, and something that would not happen otherwise without the subsidy. And they shouldn't normally, the costs, there's a principle of costs that would be funded anyway. So subsidies should not normally compensate for the costs that the beneficiary would have funded in the absence of a subsidy, of any subsidy. And then finally, they need to be, subsidies should be an appropriate policy instrument for achieving their policy objective, and that objective cannot be achieved through other less distortive means. And then there's the principle I've already highlighted above, which you can see in the definition of subsidy as well. This in relation to competition investment within the UK. So subsidies should be designed to achieve their specific objective whilst minimizing any negative effects on competition investment within the UK. And then the final principle is that it's effectively known as the balancing principle. The beneficial effects in terms of achieving those policy objectives should outweigh any negative effects, including, of course, effects on competition within the UK and/or on international trade or investment. Now, just pausing there, it is for the authority under Section 12 to now apply those principles. And the big change from those of us that are familiar with the EU state aid regime is that decision making as to whether or not those subsidies meet those principles is now with the public body, and it is not effectively going to be carried out by what happened previously was by the Commission. So the Commission was the one under Article 107(3) that would decide whether a state aid that's been notified on, whether that's compatible with the internal EU market. In effect, and the notification regime was very onerous. So there was a low bar to notify the Commission, and then it was the Commission that had jurisdiction to determine compatibility. That's all changed now. There's the rather than that wide net and everything being as much as possible being referred up to the Commission, it's now very much, and the big change is that it's now for public bodies primarily to assess for themselves under Section 12 whether subsidies comply with those subsidy control principles. Now, Barney will talk about how that's enforced and what the CMA and how the CMA might and the CAT might supervise the fulfillment of that duty. But that is the big change. There's no longer this onerous notification requirement that would automatically, if breached, would automatically render a subsidy or state aid unlawful under the EU state aid regime. That's all gone, and it's now under the control of the public body, who effectively has a discretion to decide whether these principles are met or not. There is another set of principles known as the energy and environment principles, and those are set out in Schedule 2, and I've just given you I've just set out a couple of those principles just for brevity. I haven't put them all in. Now, similar to Section 12, there's a duty under Section 13 of the Act for a public authority to consider the energy environment principles before deciding whether to give a subsidy in relation to the energy or environment. And it can't give a subsidy unless it's of the view that the subsidy is consistent with those principles. Those are a sort of added set of principles that apply just in the same way in terms of how the Act operates to the main subsidy control principles. And so I put up the two of the key principles. So subsidies should be in relation to energy environment, shall be aimed at and incentivize the beneficiary in delivering a secure, affordable, sustainable energy system and a well-functioning competitive energy market, or increasing the level of environmental protection compared to the level that would be achieved. Sorry, there should be there's a typo there, that would be achieved in the absence of the subsidy. And then quite importantly, for those dealing with contaminated land, etc., subsidies in relation to energy environment shall not relieve the beneficiary from liabilities arising from its responsibilities as a polluter under the law of England, Wales, Scotland, and Northern Ireland. Now, those are the main principles. I'll come back to what the guidance says that's been issued by BIS on and how that guidance can help in understanding how those principles should be applied. But before I do so, I just want to touch on permitted and prohibited subsidies and how the Act deals with those. So Part 3 of the Act sets out subsidies that are in essence exempt from the subsidy control requirements, and those for unsurprisingly include subsidies for purposes of safeguarding national security, subsidies given by the Bank of England in pursuit of monetary policy, subsidies given to compensate damage caused by natural disaster, etc., national global economic emergency subsidies. And then there are the minimum subsidies that fall within the minimal financial assistance provisions, MFA provisions, and then the subsidies for services of public economic interest less than £315,000. Now, those I'll come on to the minimum financial assistance provisions and the SPI, SPEI assistance provisions, because those are clearly of particular interest to local authorities, and we've already had an uptick in interest from clients asking whether the difference between those provisions and the de minimis provisions under which previous subsidies were granted under state aid. There are subsidies that are completely prohibited and can't be granted in any circumstances, and those are unlimited state guarantees, and then subsidies to restructure an insolvent phone business in the absence of a credible plan to restore it to viability. Now, so services of public economic interest, SPEI. So what is an SPEI enterprise? Well, that is defined in section 29 of the Act as an enterprise that's assigned with particular tasks in the public interest, including public service obligations. So that when assistance is intended to give a subsidy to an SPI interest, there is a specific duty under section 29 of the Act. The public authority giving the subsidy must be satisfied that the amount of subsidy is limited to what is necessary to deliver the SPI services, having regard to the costs and reasonable profits to be made in doing so. So that's a specific additional duty applying to SPI services. And then there's a requirement under section 29(3) that SPEI assistance must be given in a transparent manner, and there's a need for a written contract or legally enforceable arrangement in writing, with various specified information that needs to be included in those either those contracts or those arrangements. Now, if assistance is given to an SPI enterprise, the key modified duty, or the key difference to any other subsidy, is that the section 12 duty is modified expressly by section 29(6), which says that the duties under section 12, i.e. the duty to apply the subsidy control principles, the duty, that duty applies only so far as the carrying out of that duty does not obstruct the carrying out of those services. So section 12 cannot be an absolute bar to the granting of SPEI, an SPEI subsidy. So that means, in practical terms, that even if you are giving an SPI subsidy and that meets a subsidy to an enterprise that meets the definition, a public authority still needs to go through the steps of considering the subsidy control principles. But ultimately, the outcome of that analysis means that it cannot bar does not obstruct the carrying out of those services, so those services can still go on. Now, where this then fits in to the minimum financial assistance provisions is as follows. So there is the basic minimum financial assistance provision, which states that £315,000 of subsidies can be awarded to an enterprise within a 3-year period, and that's, you'll note, that's slightly more generous than the €200,000 de minimis threshold in the EU de minimis reg. But then, under the same provisions dealing with minimal financial assistance, if a subsidy is given to an SPI enterprise for the provision of SPI services, the total amount should not exceed £725,000. Now, there are some residual transparency requirements, but in effect, what that means is that you can grant subsidy up to £725,000 to an SPI without having to go through without having to go through all the steps necessary under the Act to grant any other subsidy. And there are no requirements at all if under £100,000. So those are the key provisions relating to the sort of minimum financial assistance and an SPI assistance, and they're contained in in sections 36 to 37 to 38 of the Act. And just to be clear, section 38 states the subsidy control requirements do not apply at all to SPI assistance given to an enterprise if the assistance does not exceed an SPI enterprise if the assistance does not exceed £725,000. So you don't even have to go through the application of those principles to that kind of subsidy. Now, just finally, in terms of the what other sort of inverted commas safe harbors are there for the grants of subsidies. So we've looked at MFA, minimum financial assistance provisions. There is envisaged under the Act a process whereby if a subsidy is granted pursuant to a streamlined subsidy scheme, then again, it won't have to go through the subsidy control requirements. Now, the Act envisages that those streamlined schemes will be issued by secondary legislation, and they won't need to go, for example, to the CMA for review. Now, it seems to be that the intention is for those to operate in similar way to what we're all familiar with under the EU block exemptions. So if a subsidy meets one of the conditions for the streamlined schemes, it won't need to go through the Section 12 duty, etc. And it also won't need to be referred to the CMA. Now, as far as I'm aware, and I haven't, there's been nothing in the last couple of weeks that I'm aware of that suggests when those streamlined schemes are going to be laid before Parliament and then come in via secondary legislation. I can't find any reference on the BIS website as to when that's going to happen, and that's quite surprising because, in essence, the EU block exemptions, although quite detailed to read and fairly tortuous to go through in their labyrinthine detail, did provide a huge range, or did exempt a huge range of subsidies from the EU regime. And it's slightly surprising so far the government hasn't published the sort of blanket exemptions that would free up a lot of granting of subsidies by UK bodies in a similar sort of way. Now, I don't know when that is going to come in. All we know is from the government policy statement in January 2022, we are told that the government will introduce schemes at especially low risk of causing market distortions that promote UK strategic policy objectives and which the government judges to be compliant with the subsidy control regime. But as I say, no further detail as yet. And as I say, we're less than a month before the Act comes into force. So watch this space, because I think I'd be surprised if there's nothing that's published before January. Now, I mentioned the statutory guidance that's issued by the government. Under Section 79, there is a standalone duty to have regard to the guidance when giving a subsidy. The guidance is not an authoritative statement of law, of course, and it says that in terms. The guidance was out for consultation during the summer and the autumn, and it was issued on about 3 weeks ago, on the 25th of November 2022. Now, the chapter 3 is clearly the key chapter of this guidance, because that sets out in some detail how subsidies should be designed and assessed against the 7 subsidy control principles. It does say that the depth of analysis and effectively the depth of audit that a local authority needs to go through needs to be commensurate to the size and potential distortive impact of the subsidy or scheme in question. But if there was one sort of takeaway from this guidance, there's one part that I would recommend any public body to have a quick read up on now, would be the 4-step assessment framework that the guidance sets out on page 32. And what that does is effectively collate the 7 subsidy control principles I've referred to earlier, and puts it into a 4-step framework in quite a useful way, and quite a practical way for a public body to apply. So you have step 1, identify a policy objective, make sure it addresses market failure or an equity concern, and then step 2, ensure the subsidy is designed to create the right incentives for the beneficiary and bring about a change. Step 3, consider distortive impacts, keep them as low as possible. And then step 4, carry out that balancing exercise that I referred to earlier under the 7th principle, Principle G. The guidance is a long document. It's I think about 90 pages. There are some good examples in there of things like an SPI, particularly on SPI assistance, etc. Well worth taking a look, particularly for public bodies who are beginning to start thinking about what they do in 2023 and how they're going to design, and more to the point, lay the correct audit trail down to enable the lawful grant of subsidies going forward after the 4th of January. Just in summary then, what are the key features of the scheme in terms of how it differs to what we've been familiar with under the EU scheme? There is certainly a great deal more flexibility, and however, coming alongside that greater flexibility is less certainty. So the prescriptive conditions of the GBER, the block exemption regulations, are gone, but now what we have essentially is the necessity to apply 7 quite high-level subsidy control principles, and also the duty to apply the statutory guidance I've referred to. Now that's going to give rise to, inevitably, to some uncertainty, which comes on with the discretion conferred on a public body. And importantly, the decisions taken and the way in which those principles are going to be applied is in essence now subject to judicial review. So the standard of review is going to be based on, for example, when domestic principles, public law, Wednesbury unreasonable, material considerations, etc., not the sort of full merits review that we had when when state aid was notified up to the Commission, for example. So that's the big change, a lot more discretion afforded to local authorities. As I said earlier, gone are the onerous notification requirements, which if breached would automatically render state aid unlawful. And gone is the delay the notorious delay that we were used to when state aid was referred to the Commission. Barney will touch on this, but it seems to me there's going to be a much more limited number of subsidies that will need to be referred up to the CMA. As I said, there's the new novel intra-UK test when assessing effect on competition or investment, and that does set a relatively low bar. There is going to be the need for, it seems to me, streamlined schemes to assist, for example, in the government's levelling up agenda in the absence of the, for example, the regional aid exemption under the EU regime. And at the moment, however, that's still TBC and we still don't know. And as I said, there's also going to be a need for a significant number of streamlined schemes to replace, in effect, what we had under the GBER in EU law, under EU law, and there are multiple categories of state aid that don't need to be notified. So, but details TBC. So anyway, that's a canter through the Act in just under 45 minutes. I'm now going to hand over to Barney, who is going to talk about review and enforcement and the role of the CMA and the CAT. Thank you.
Thanks very much, James, and hi, everyone. I'm going to talk about, as James said, review and enforcement under the Subsidy Control Act, and three topics in particular. So the first is referrals to the Subsidy Advice Unit. That's the new unit within the CMA that's been set up. The second topic is the transparency requirements that now apply to public authorities. And the third is reviews of subsidy decisions and enforcement action before the Competition Appeal Tribunal. So turning first to the Subsidy Advice Unit, and to do this, I just want to recap. So if we step back a bit, as James has already explained, the first thing that needs to be done is to consider whether the proposed measure is a subsidy or subsidy scheme. So that involves the type of evaluation that everyone's familiar with under the previous state aid regime. It's similar in terms to that. If the measure is a subsidy, the authority then needs to consider whether a prohibition applies that would prohibit the subsidy outright. So, for example, if the subsidy would guarantee an unlimited amount of liabilities or debts, that's prohibited outright, and the public authority cannot make that subsidy. The public authority also needs to consider whether there's an exemption that applies or whether the subsidy is made pursuant to a streamlined route. So if the measure is being given, for example, to respond to a global or national economic emergency, then it will fall within an exemption within the legislation, and the public authority can award the subsidy. But if, and this is the fourth bullet point on this slide, if the measure is a subsidy and is not exempted or prohibited, then the authority needs to assess that against the subsidy control principles, and that's the self-assessment process that James has explained. If we then kind of move to the overview of the referral process, that self-assessment and the ability of the public authority to simply award the subsidy isn't the end of the story for certain types of subsidies. For certain types of subsidies, they need to be, or they may be, referred to the Subsidy Advice Unit in the CMA. So if the subsidy is of particular interest, and that's the definition within the the regulations that are enacted under the legislation, then it must be referred to the Subsidy Advice Unit. That's a mandatory referral. If the subsidy is a subsidy of interest, then it may be referred to the Subsidy Advice Unit by the public authority. So that's a voluntary referral. And certain subsidies must be referred to the Subsidy Advice Unit by the public authority if the Secretary of State issues a call-in direction. So that's another process of mandatory referral that can occur before a subsidy can be awarded. If a subsidy is referred to the Subsidy Advice Unit, then the unit examines the subsidy and then it can provide advice to the public authority about the proposed award. There is a further process of referral, and that's post-award referral. So if the Secretary of State decides to, the Secretary of State can refer certain subsidies to the Subsidy Advice Unit after they've been awarded by the public authority. And I'm going to explain all those referrals in greater depth now. So if we turn first to mandatory referral, and that's subsidies of particular interest. If the subsidy is of particular interest, the public authority has to refer it. If they do not refer it, then the subsidy is prohibited. So what is a subsidy of particular interest? Well, that's defined in the quite pithily named Subsidy Control, Subsidies and Schemes of Interest or Particular Interest Regulations 2022, and they'll come into force in 2023. Broadly speaking, a subsidy is a subsidy of particular interest if the amount of the subsidy exceeds £10 million or it's over a lower threshold, but accumulation rules apply, or the subsidy concerns a sensitive sector and exceeds £5 million, or the subsidy is expressly listed as a subsidy of particular interest in the legislation. So, for example, certain restructuring and relocation subsidies are expressly listed as subsidies of particular interest. What are sensitive sectors? Well, those are sectors that are deemed to be having greater potential to be distortive on competition. So, for example, car manufacturing or certain types of metal production. What about voluntary referral of subsidies of interest? Well, as I've said, these are subsidies that the public authority may refer to the Subsidy Advice Unit. It doesn't have to. And again, these are defined in the regulations. In short, a subsidy will be a subsidy of interest if the total amount of the subsidy exceeds £5 million and it's not a subsidy of particular interest, or if it's expressly listed as a subsidy of interest in the legislation. So this covers, for example, rescuing provisions. So that's mandatory and voluntary referral of subsidies of interest and particular interest. What about call-in directions? There's call-in directions provides an additional route of referral to the Subsidy Advice Unit before the subsidy award can take place. So under a call-in direction, the Secretary of State can direct a public authority to refer its proposed award to the unit. And again, if the public authority fails to do that, the subsidy is prohibited. So the Secretary of State can do so in two circumstances. The first is if there's a subsidy of interest, and the second is if the Secretary of State considers that there's a risk that the proposed subsidy would fail to comply with the subsidy control requirements or could negatively affect competition or investment in the United Kingdom. So those are the three pre-award referral routes. What should the public authority provide the Subsidy Advice Unit with when it refers an award? It needs to provide an explanation as to why it considers that the subsidy would meet the criteria for being a subsidy of interest or a subsidy of particular interest. The public authority needs to provide the unit with the assessment that it carried out of the subsidies compliance with the subsidy control principles and any evidence that was relevant to that assessment. And the authority also needs to provide the subsidy advice unit with the information that the authority would be required to upload onto the subsidy database. And I'll come onto the database in the next section when I discuss the transparency requirements. The CMA has issued its own guidance on the operation of the subsidy advice unit, and that should be referred to when making referrals to the subsidy advice unit. So the guidance sets out the types of pre-referral discussions that the subsidy advice unit could entertain and the information that should accompany a referral to the unit. The public authorities should use the unit's online public authority portal when making a referral to the subsidy advice unit. So what happens after a referral is made to the subsidy advice unit? Well, the unit needs to take certain steps, and the steps that it takes depends on whether the referral is mandatory or voluntary. So for mandatory referrals, so that's referrals by public authorities for subsidies of particular interest, and also referrals for subsidies that have been called in by the Secretary of State, the unit must notify the public authority within 5 working days as to whether the authority has complied with the procedural requirements for requesting a report from the subsidy advice unit. And if the procedural requirements were complied with, the subsidy advice unit must publish a report within 30 days. There's then a cooling off period of 5 days in which the authority can't make the subsidy. For voluntary referrals, the process is slightly different. So that's referrals by public authorities of subsidies of interest. So in these circumstances, the unit first needs to decide whether to prepare a report at all. It does not have to prepare a report. It then needs to notify the authority within 5 working days that a report will be prepared, or if it decides not to prepare a report, explain why it will not prepare a report to the public authority. And then if the unit decides to prepare a report, it needs to publish that report within 30 days. And unlike mandatory referrals, there is no cooling off period. So that means that a public authority can award the subsidy before it receives the subsidy advice unit report. And the CMA guidance on the subsidy advice unit is quite helpful in outlining the circumstances and the prioritization principles that apply to the subsidy advice unit in determining whether to produce a report in response to a voluntary referral. So what does the subsidy advice unit's report include? Well, it will roughly include the same content irrespective of whether the referral was mandatory or voluntary. So it has to include an evaluation of the authority's assessment of why the subsidy complies with the subsidy control principles. And that evaluation must take into account the effects of the subsidy on competition investment in the UK. The report may include advice about how the authority's assessment could be improved and how the subsidy could be modified to better ensure compliance with the subsidy control principles and requirements. And it's important to remember that the reports and the advice of the subsidy advice unit aren't binding on public authorities. So while there are obvious reasons for why a public authority might follow the report and advice of the subsidy advice unit in order to reduce the risk of a successful challenge to its decision, it doesn't have to. The reports are published and copies are provided to the Secretary of State. So there's one further, as I mentioned, there's one further route of referral, and that's referral after an award's been made. So the other 3 types of referrals that I've explained are all pre-award referrals. And for post-award referrals, that's when the Secretary of State decides to refer a subsidy to the Subsidy Advice Unit after the subsidy has been given. And the Secretary of State could do so if the Secretary of State considers that there's been a failure to comply with the Subsidy Control Principles, or if there's a risk of negative effects on competition or investment in the UK. If the Secretary of State decides to do so, it has to direct the public authority to provide its assessment to the Subsidy Advice Unit, as well as any evidence that the public authorities relied on in support of its assessment. And the Subsidy Advice Unit must publish its report within 30 days, but that period can be extended by agreement between the Subsidy Advice Unit and the public authority. So that's referrals to the Subsidy Advice Unit. I'm going to turn very quickly to the transparency requirements that apply to public authorities, and these shouldn't take that long. Right, so BEIS has already created a publicly accessible subsidy database, and that allows anyone to view details about subsidies that have been awarded by public authorities. There's a separate portal for public authorities to upload information about subsidies that they've been awarded. And I've included links to those on the slides. For subsidy schemes, public authorities must ensure that the relevant information is uploaded onto the database within 3 months of the authority's confirmation of its decision to make the scheme. And there's an exemption. So authorities do not have to upload information with respect to individual subsidies that are granted under a subsidy scheme if those individual subsidies are valued at 100 grand or less. For individual subsidies awards, it's slightly different. The same time limit applies of 3 months, but there's no threshold exemption of 100 grand. So the details of all subsidies, of all individual subsidy awards, save for some that are exempted in the legislation, must be uploaded onto the database. So the transparency obligations apply at a very low threshold, and that's very different from the previous regime under EU law. So what kind of information needs to be included on the database? Well, the government has introduced regulations that set out what information needs to be included. And these are the Subsidy Database Information Requirements Regulations 2022. So, for example, for a subsidy scheme, the authority needs to provide details like the name of the subsidy scheme, the amount budgeted for the scheme, the form of the subsidy under the scheme, the sector for which the subsidy scheme is available, a pretty detailed description of the subsidy scheme, the policy objective which the scheme is designed to promote, and much more. So it's significant amount of information that needs to be uploaded onto the database, and it's very much in the public authority's interest and also the beneficiary's interest for that information to be uploaded, because the time for challenging the subsidy award decision, if an interested party wishes to, may not run until the information is uploaded. So the quicker the information is published, the quicker the subsidy will be free from the risk of challenge. And I'll come on to challenge now. So reviews and enforcement action in the Competition Appeal Tribunal. So reviews before the Competition Appeal Tribunal, an interested party can apply to the CAT for a review of a public authority's decision to give a subsidy or make a subsidy scheme. It is the decision of the public authority that's amenable to challenge. It is not the reports that are produced by or the advice that's given by the Subsidy Advice Unit that should be the target of any challenge. In terms of an interested parties, An interested party is anyone whose interest may be affected by the giving of the subsidy. So that may be a competitor of the beneficiary, or it may also be a public authority. That will be fact dependent. The information that's provided by the public authority as part of its transparency obligations that I've already explained, that information is designed to assist interested parties in challenging awards. But interested parties can request additional pre-action information under Section 76 of the Subsidy Control Act, which public authorities must provide. And Section 76 outlines the circumstances in which public authorities must provide that information. The time limit for challenging decisions of public authorities is 1 month from the relevant date. And that's broadly speaking 1 month from the upload of information onto the database, but there are exemptions, so it's worth checking the CAT tribunal rules as amended by Section 71 of the Subsidy Control Act. In terms of the CAT's determination of reviews, the proceedings follow the Competition Appeal Tribunal Procedural Rules 2015. The Competition Appeal Tribunal can review whether the public authority discharged its duties, and particularly whether the public authority assessed the subsidy properly against the subsidy control principles on public law grounds. So that's, in essence, principles of judicial review. So that means that the tribunal can look at whether the public authority's decision was lawful. It can't look at the merits of that decision. It's a question of review, not remaking the decision. And that may involve the tribunal reviewing whether the decision was within the authority's powers or whether it was irrational, JR principles. The tribunal will not review the effectiveness of a subsidy or subsidy scheme, because that will leak into a merits-based decision. The tribunal's powers on review are similar to the powers in relation to judicial review. So the tribunal can grant similar forms of relief. So it can grant a mandatory order, a prohibiting order, a quashing order, and it can also grant a recovery order, and that's under Section 74 of the Act. So if the tribunal finds that the authority did not comply with the subsidy control requirements under the Act, it can order the public authority to recover the subsidy from the beneficiary. Section 31 of the Senior Courts Act applies. So that means that if the CAT, it means that the CAT must refuse to grant relief if it appears highly likely that the outcome would not have been substantially different if the conduct complained of had not occurred. So if it would have made the subsidy anyway, unless there are reasons of exceptional public interest to grant relief regardless. And if the CAT grants relief, then as I said, it can make a recovery order. In terms of appeals and recovery of misused subsidies, parties can appeal a competition appeal tribunal decision on a point of law to the Court of Appeal. Under Section 77 of the Act, a public authority can recover a subsidy from a beneficiary if the subsidy has been used for a purpose other than the purpose for which it was given. And the authority's right to recover a misused subsidy is enforceable as if the subsidy were created by contract between the public authority and the beneficiary. So that covers the authority's ability to recover a subsidy that's been misused. I think that's broadly speaking everything. What I've done is I've included some of the key rules and regulations on this slide. So that's the regulations that define the subsidies of interest in a particular interest, as well as the regulations that set out the information requirements that apply, and also the Competition Appeal Tribunal rules that determine how the proceedings in the CAT will be followed. As James has already mentioned, there's really two key types of guidance. The first is basis guidance, statutory guidance, and the second is the guidance that's being produced by the Competition and Markets Authority that provides guidance on the operation of the subsidy control functions of the new subsidy advice unit. And I think, broadly speaking, that's everything that I wanted to cover. So I think we can move on to some questions.
Yes, thanks, Barney, for that overview of the review and enforcement regime. I think in terms of the questions that we've received, I've had a look at some of the categories of questions, and I'm going to sort of fall on my own sword and ask myself a question that's been raised by one of our participants, and that relates to the public authority test. So and how that overlaps with the test for a public authority under the public contract regulations. And I think the particular inquiry linked is raised in the context of housing associations and universities. Now, I didn't go into any detail on what the Act says or how the Act defines public authorities, but that, just for everyone to be clear, that's set out in section 6 of the SCA, and that says, for the purpose of this Act, public authority means a person who exercises functions of a public nature, but doesn't include the Houses of Parliament. Now, that test of exercising functions of public nature is in essence a repetition of, I think, the data-fin test for public bodies. So that's the test under domestic UK public law for what is a body amenable to judicial review. Under the PCRs, under the public contract regs, a contracting authority is defined as state, regional, or local authorities, bodies governed by public law, or associations formed by one or more such authorities governed by public law. Now, that governed by public law test is a very specific one based on EU law, and it is different to the test of the function test under section 6 of the Act. So it seems to me that, at least on the face of it, and I think from recollection, it's a narrower test. So governed by public law is a narrower test than the UK law test for what is a public body, which is related to functions, not just whether it's governed by public law. So it does seem to be, so the first sort of limb of the question, are the two synonymous or broadly the same? No, they're not. There seems to be it seems the SCA seems to catch more public authorities than the PCRs. As to whether housing association universities are caught by that pass, because I think that all depends on whether they're exercising functions of a public nature. I seem to recall universities have been amenable to judicial review in the past, certainly in the field of education law, etc. So and as for housing associations, again, not sure. Depends. I haven't advised housing associations specifically. But if they are exercising functions of public nature, on the face of it, they might well be. They're going to be caught by Section 6 of the Act. There's another question which we've been asked, quite an interesting question about modifications and legacy schemes. So again, might be worth me just touching on this. And the question is, there's a specific question about whether the allowance for modifications to subsidies, and whether it then counts as a new subsidy, whether under Section 81 of the Act, those are effectively cumulative, so you can take advantage of all of them, or whether you can only rely on one or two of those if you're a legacy scheme. I'll just to answer that question, and I thought it'd be helpful if I just give an overview of what the provisions are in the Act for legacy schemes, because there is a provision that makes it clear that up until the date of the coming into force of the Act, a subsidy granted under a subsidy scheme is exempt from the requirements. And I think that's section, bear with me, I think that's at section 4, somewhere in the 40s, under the miscellaneous exemptions. Yeah, sorry, section 48. So that deals with what's described as legacy and withdrawal agreement subsidies. And that states that subsidy control requirements do not apply to the following legacy subsidies and schemes. A subsidy given, and this is the key definition, a subsidy given or after the day in which section comes into force under a subsidy scheme made before that day. So that means you don't have to go through, you don't have to go through the Section 12 duty and applying the principles if you've already granted those sorts of subsidies. And there are some quite, I won't read them all out, but there are some fairly specific references to other subsidies, something to do with rail and road subsidies given in relation to passenger transport services, etc., etc. So that's broadly the position with legacy subsidies. When one looks at the modification provisions under Section 81, I don't think I'll be able to bring this up on the screen, but Section 81 makes provision for modifications and states that the modification of a subsidy or a subsidy scheme is to be treated for the purpose of the Act, is the giving of a new subsidy or the making of a new subsidy for the purpose of the application of subsidy control requirements. So a bit like in PCRs where you're modifying a contract, etc. You're obviously, if you modify something on the face of it, that constitutes a new subsidy. It then disapplies that catch-all provision and subject to and then Section 81(3) states sets out what might be permitted modifications, so effectively sort of safe harbors for modifications that would otherwise be caught. And that states that a modification to a subsidy scheme is a permitted modification if it is, for example, of any of the following kinds: a legacy subsidy modification. So and then that's defined as the modification of those type of legacy subsidies I've already referred to. But it has to be as permitted under the subsidy or scheme in accordance with its terms as they had effect before coming into force of this section. So if the subsidy scheme has provision for those sorts of modifications, then that's okay. I think the question is, the specific question is whether there's also a provision for an increase. A permitted modification can include an increase of 25% of the original budget for the subsidy. And the question is whether you can effectively modify a legacy subsidy under that provision, but then also take advantage of that 25% sort of uplift or that separate provision. Now the guidance, as the participants raised, the guidance is might be a bit unclear on this, because the guidance suggests, I think it round about section 9, that you can effectively sort of wrap all of these, take advantage of all of those, that uplift of 25% and also a legacy uplift. I must say, instinctively, it doesn't say that in the Act, and I'd be quite wary of that being the case, because it does seem to be, you have to identify which of the limbs under section 81.3 you fall within and then take advantage of that, rather than sort of effectively accumulate those. So that some care needs to be taken, I think, and the participant's question is right to raise it, that the guidance might not necessarily be accurate in that respect. And if it's suggesting, I'm just trying to check that provision in the guidance, if it's suggesting that you can effectively take advantage at the same time of two of those permitted modification sort of routes. So those are my sort of self-adopted answers to those particular questions. I'm now going to see if Barney can help with a couple of others, because they seem to fall within his bailiwick. And bear with me, I'm just going to pull those up again. I think the first question, Barney, that might be one for you.
I can see one just very quickly on my.
You got one that you'd like to take?
There's one that I can see which we can deal with quite quickly, I think, and that's a question about minimal financial assistance and the way in which the transparency obligations apply to that. I think in terms of how the transparency obligations apply to MFA, they don't apply if the subsidy is 100 grand or less, but they do apply if the subsidy exceeds that amount. So that's as I understand it, the position with regards to MFA and transparency obligations. James, I don't know if you want to throw any more my way. I'm just going to.
I've got one question that might be. I think it's just worth clarifying. So, and this is in relation to the failure to assess a subsidy under the Subsidy Control Principles. So, if you have an example where a public body has failed to assess the subsidy against those principles, but it's under a duty to refer that subsidy to the CMA, what happens? What does the Subsidy Advice Unit do? Does it still write a report, or how is that sort of situation catered for, where there's been a failure to assess the subsidy in the first place and its principles?
Yeah. So if the authority doesn't provide an assessment, if it hasn't assessed whether it's a subsidy of particular interest or a subsidy of interest, or it hasn't assessed compliance with the subsidy control principles, what the Subsidy Advice Unit has to do is report that fact. So the fact that the public authority has not assessed, has not carried out that assessment, along with any reasons that the authority has provided for not producing that assessment. So it's not the case that the Subsidy Advice Unit does nothing in response to that. it needs to report on that fact, because obviously that in itself could be grounds for challenge.
Okay, that's helpful. I think we've got time just for one more. Barney, I don't know if you can see the Q&A, because my screen for some reason hidden them, but if there's any that you feel like you'd be able to pick up.
Yeah, there's one which is which I could deal with quite quickly, I think, and that's whether an authority can ask the subsidy advice unit to produce a report, even if the subsidy isn't a SOPI or an SOI. The short answer is no. Public authorities can't just request reports from the subsidy advice unit in order to make sure that the subsidy that they want to grant is compliant with the subsidy control principles. But that doesn't mean that public authorities can't request support. So I think the Bayes guidance is quite helpful in this regard, and it sets out various sources of support and advice that public authorities can request. So that's from, for example, the subsidy control team at Bayes. And also, it obviously doesn't mean that just because a public authority can't request a formal report from the subsidy advice unit, that a public authority is prevented from engaging with the subsidy advice unit ahead of a referral request that it might make, in order to discuss how it makes that request and the information that it needs to provide as part of the referral. But in short, it's not the case that public authorities can take a precautionary approach and just make referrals to the subsidy advice unit if the subsidy is not a subsidy of interest or of particular interest.
So, because I mean, and this was a question, you know, that I know is of interest, more wider interest than something we've discussed. But
yeah, effectively,
you could have a scenario. So you could have a scenario where a public body, something's not an SPI or a so it's not doesn't need to go to be referred, but it is a subsidy, and the authority may have just not applied the principles at all. And in that case, it seems like if a third-party competitor is aggrieved by that grant of that subsidy and wants to raise a breach of Section 12, for example, that is probably likely to be, and on the face of it, seems to be something that would have to be heard by the admin court for a breach of the Section 12 duty, not something that falls within the CMA CAT kind of sort of jurisdiction. Is that? I mean, it's a question of whether it does seem to be a question of whether something is a subsidy or not. It's a question of law, or if there's any discretion accorded to a public authority. But the route for that would seem to be a JR in the admin court. I'm right in saying that.
And I think it's worth mentioning, just on a practical level, the Bayes statutory guidance is pretty helpful in outlining the steps that should be taken in determining whether a measure will be a subsidy. So in terms of legal challenge, if a public authority follows those steps and follows those procedures, that will significantly reduce the scope of challenge, given that it's going to be on judicial review principles, so subject to irrationality or failure to take into account material considerations grounds.
Very useful. Well, thank you very much, Barney, and thank you to all our participants, particularly those. I can see that there's a number of other questions we haven't had time to answer, but if you do want to get in touch after this, please get in touch with the clerks at landmarkchambers.co.uk. And it just remains me to, as I say, to thank you all for participating. We're ending bang on time, or 3 minutes just before the end of this scheduled session. Thank you very much. We may be doing a follow-up session on this area, perhaps possibly swept up with the new public procurement regime that's going to be coming in at some point in 2023 as well. So perhaps in the next 5 to 6 months, there'll be a follow-up seminar. But thank you very much, and the materials will be distributed, as I said earlier, through the Landmark marketing team, should you want a copy of the presentation and the recordings. Thank you very much.